So first off, just welcome everyone. Thank you for joining us for our second Youth Justice Action Month workshop. This one is entitled Treating Kids Like Kids. Before we get started, just want to hop into a little bit of housekeeping for everybody. If you aren't presenting, we just
Ricky,
it's like I might have gotten muted in that process. So yes, please, if you're presenting, we ask that you please mute yourself. If you aren't presenting, excuse me. We have a large crowd for today with lots of new faces, and we'd like to get to know all of you a lot better. So please feel free to introduce yourself in the chat. You can leave your name, your state, and any affiliations that you happen to have. In the interest of time and trying to keep everybody together, if a question does pop up or arise for you while people are presenting, please just drop it into the chat and we'll do our best to try and elevate it during the Q&A portion at the end of the workshop that we're going to reserve time for folks to ask those questions. And just a little bit more about today's workshop. We're joined by some great folks, some excellent folks that I've had the pleasure of being able to work with here. But this week we are talking about policies to ensure that no youth are tried as adults. The adult justice system is no place for children. We all know that. That's why we're here. And children are at increased risk of abuse, suicide, and harm when they come into contact with these systems. So we know we need to change our laws and policies so that youth can get access to the needed resources and supports and services that we all know work and not throw them into adult prisons. So in today's workshop, we're going to learn about various policies and efforts that reduce the number of youth in the adult system. And we'll hear about a variety of different things. We're going to talk about interrogation laws. We're going to talk about ending direct file and extreme sentences. And then we're going to talk about reforming laws for victims of sex trafficking. So at this point, I think I'm going to turn it over to Allison to introduce our presenters and kick us off. Thank you, guys.
Yeah, I'm thrilled to introduce our speakers. Just before that, we wanted to sort of connect the dots on why we're talking about all these issues today. So we know that sort of the adultification process for young people really starts at interrogation, where youth are brought into police stations and not given access to their parents, not given access to attorneys, and really are questioned as though they're adults. And it continues the deeper we go into the system when youth are pushed into adult courts or when they're subjected to extreme sentences. So we really just wanted to have this conversation today, really tie all those pieces together and hear from our brilliant experts. So I am thrilled to introduce them. We have them highlighted on the screen for you guys. So our interrogation experts today are Michael Mendoza and Oscar Canales of the Anti-Recidivism Coalition. Michael is ARC's National Advocacy Director and leads the Anti-Recidivism's federal advocacy work. And Oscar is ARC's leader on California-based policy, and he's played a lead role in moving their reform work on youth interrogation laws. And then on our direct file and transfer expert is Marcy Mistreat. You guys might know her from the Campaign for Youth Justice. She's now the director of youth justice at the Sentencing Project, where she works to make sure that youth are not tried in the adult criminal justice system. Our extreme sentences expert is James Dold. He's the CEO and founder of Human Rights for Kids, and he was previously with the Campaign for the Fair Sentencing of Youth, where he did lots of work to reform policies all around the country to end juvenile life without parole. And then our girls' rights expert is Yasmin Bafa. She's the co-founder and executive director of Rights for Girls. She's a human rights attorney and advocate, and her work focused on the intersection of race, gender, violence, and the law. So with that, I'll turn it over to you, Michael and Oscar, to get us started talking about the work on interrogation.
Thank you, Allison. Oscar and I are going to have the pleasure of boring you all with our personal stories around Miranda rights for youth. Well, first of all, I'm not just the director of national advocacy at the Anti-Recidivism Coalition. I've also been a member of the Anti-Recidivism Coalition, a nonprofit organization based in Los Angeles, California. Oscar, you're on mute.
Yes, hello everybody. Good afternoon. My name is Oscar Canales. My pronouns are he, him, his. I'm a youth advocate with the Anti-Recidivism Coalition. It's an honor and pleasure to be here speaking in behalf of these issues.
And one of the things we want to talk to you about is our federal priority, which is HR 2834, authored by Congressmember Tony Cardenas on the House side. But we're also very, very fortunate enough to have a companion bill on the Senate side authored by Senator Cory Booker, S2498. And essentially what this bill would do on the federal level is protect the Miranda rights of youth, ensuring that kids are provided an opportunity to speak to an attorney before they waive their Miranda rights, that their parents are notified when a child is taken into custody. And this bill targets kids who are 18 years of age or under the age of 18, excuse me. So 14, 15, 16, 17, kids under the age will be receiving these protections, hopefully when passed on the federal level. Really briefly, our organization is made up 75% of formerly incarcerated individuals. Our executive directors formerly incarcerated themselves, and we prioritize issues mostly around kids because we know that when we are talking about the brain development, the brain science, and the resources that kids need at a young age, this is what we want to try to emphasize. Oscar Canales has done an amazing job on the state level, passing a bill that mirrored our federal efforts that he can explain.
Yes, thank you. The bill is SB 203, which in other words now allows a juvenile, once he is detained and being interrogated, there must be a lawyer present to be able to fully explain what is the process and what is going on. Because we understand now that when children, the United States Supreme Court has recognized the following, that when the children are less mature, and under these pressure, under these circumstances, I could personally attest to it, that when you're being interrogated, half the time you're not even thinking about what is being said. What you're thinking about in the moment is you're in shock, you're scared, in other words, or you're just complete blank. And that comes with being a child, that comes with being a kid. And I feel that now with the lawyer being present, now we have that in the state of California, where now where a child is being interrogated, a lawyer is there to explain to a child to be able to hold his Miranda rights. Because when you are being told you have the right to remain silent, half of the children in the juvenile halls can tell you that they do not remember that. They cannot tell you and sit there and tell you the specific moment where that occurred, because everything is happening so fast. And half the time the children will say things that ultimately will put them in a situation, as we have seen with New York, Netflix. A lot of the children will tell it themselves and put themselves in situations that never really happened, just because they're under pressure or they're, in other words, scared. So with SB 203, that now allows a lawyer to be present in the room when they're being interrogated. And that is awesome, because the people that are mostly impacted are children of minority, children of color, indigenous people, and African Americans, that for so long we have been subjected to racist and biased treatment. And now we are able, a step forward, to be able to know what is occurring to us and what is and understand the process. So that's what SB 203 does and how it mirrors this bill.
Thank you, Oscar. And unfortunately, it took us quite a while to pass that bill in California, in partnership with the Human Rights Watch and Elizabeth Calvin, starting in 2016. We had to incrementally reach up to age 17 to provide these protections, starting under 16. And as we were able to educate the legislature in California as to why it was important to increase the age to 17, we were able to finally even get bipartisan support in California. So this is a bipartisan issue. I had the pleasure of walking into legislative offices with Oscar. Both of us have a personal story, being incarcerated at the young age of 15, facing adult sentences. I unfortunately had to go to adult prison systems, where I grew up for 17 years in adult prisons. Oscar unfortunately had to spend his time in DJJ, Youth Correctional Facility. And so being able to provide these firsthand experiences of what it's like to be interrogated at such a young age really helped educate the legislature. And so now we're trying to expand this federally, and we need your support. Not only by continuing to urge Congress in support of the Cardenas and Senator Booker bill in the House and Senate, but to continue to educate why these age-appropriate protections, especially when we are talking about constitutional rights. constitutional rights that kids deserve to be protected, and understanding that they're far different from adults. And I actually have a cheat sheet here that I really recommend everybody to look at when it comes to how other states are faring. The Human Rights for Kids, James Dole's organization, has done an amazing job with their 2020 state ratings report. If you have not read it, please do. Why I will say that is because out of all 50 states, only 3 states have done something similar to California. And that is Virginia, North Dakota, and California. These are the only states that are providing constitutional protections for kids that are very, very necessary. And, you know, what more can we say besides, you know, we're talking about constitutional rights. We're talking about kids who are dealing with childhood adverse traumas, being thrown into a police interrogation room with tactics that are using adults while we're trying to figure out what did we do to get there to begin with, why we made decisions that we did, what's next, and you know, when do we go home? It's a very, very difficult situation for kids. Like Oscar said, if you all are very, very familiar with the Central Park Five, we have a board member, Jerome Dixon, who went through the similar situation as they did. At the age of 17, being interrogated for over 24 hours and being falsely accused and being falsely convicted, and spent about 27 years in adult prisons. And when he was finally found suitable for parole, the parole board on record recognized his innocence. And so he's been home now to this day, doing a remarkable job advocating for these issues and many others. So we hope that all of you will continue to just help us to gain more support around this issue that is desperately needed on the federal level. And with that, I'll hand it back to Allison.
Thanks so much, Michael. So I just want to recognize that we had staff from Cardenas's office join us. And so thank you for sponsoring the interrogation bill that Michael and Oscar just covered. And just wanted to welcome and thank you. And we'll turn it over to Marcy to talk more about direct file and transfer process.
Hi, everybody. It's nice to see such a crowded house today. And I want to thank Michael and Oscar. A lot of times we ask folks to share their stories and we always ask for a segment, right? So just share this slice or this slice. But I think it's really important to note that the harm that the carceral system places on people is really holistic. And I think that any young person that you talk to that has been charged or treated as an adult in our criminal legal system has had very difficult experiences during interrogation, during their pre-trial incarceration, whether that was in an adult facility or a youth facility, and then post-sentencing, whether they came home on probation or were sentenced to time in prison. They lost their protected status as childhood, and that has lifelong implications. So Michael and Oscar, thank you for showing up comprehensively in this space. We really appreciate you and the unfortunately tens of thousands of people like you across the country. So I'm here to talk about automatic transfer. I want to be clear that the bills that we're talking about in the federal package all only impact the federal law, right? And we unfortunately don't have any idea how many children that is because the feds don't count, which is true in the vast majority of states. No one counts number of kids other than those judicially waived, which we know is the smallest number of kids in the country. The same is true at the federal level. So I'm here to talk about House Bill 2908, and Representative Karen Bass is leading that bill. We do not have a House sponsor a Senate sponsor for the whole bill, though there are pieces of it that are in various bills in the Senate. I'm only here to talk about one piece of her bill, and what that does is it ends direct files in the federal system. So as many of us know, there are many ways that children can get into the adult system. They can be waived there by a judge. They can be statutorily excluded by state or federal legislatures based on the charge and age of a child, or they can be direct filed into adult court by prosecutors. And then also we throw in the age of criminal responsibility there, though that's been fixed everywhere except Texas, Wisconsin, and Georgia. So in the federal system right now, can be direct filed on into adult court on a set of criminal charges. This would eliminate that ability to automatically directly file children into the adult court. It would require a transfer hearing, and it would eliminate the ability to transfer children under the age of 16. Right now that age is 13, so that's significant. Shout out to California, because they're the only state now that prohibits transfer for any child under the age of 16. And we know internationally people have called on this being a human rights issue for anyone under 18, though we still do that quite a bit. So the BAS bill would end direct file, raise transfer to 16. It would collect data so we know who actually these children are who are going into the federal system. And it ends the ability of felony murder to be included in those statutes. So that's all really, really important work. And I want to say that I think the reason we were even able to get here at the federal level is the movement that has happened in the states. While only 13 states ever allowed direct file, that is being rolled back in many states. When I say direct file, I am saying a lot of states use that interchangeably with what we call statutory exclusion. So the difference is, does the state require a child at a certain age and charge to be in adult court, or is that decision-making authority given to the prosecutor? I know that's a slippery slope because charging falls in the hand of the prosecutor anyway, but that's the main decision. I'm going to share my screen for 1 second here so you can see the progress that we've made. So here you can see the movement in the states, right? So states that are in green have ended automatic transfer. When I talk about automatic transfer, I'm including mandatory waiver by a judge, statutory exclusion, and direct file. California ended direct file, so did Vermont. The blue states here narrowed it. So they either took charges off, eligible charges off, or they raised the minimum age where children can be qualified to go to adult court. And then the states in brown are states that expanded what we call reverse waiver, which means in situations where a child is automatically placed into the adult system, there's actually a mechanism by which some of those children can return to juvenile court, either by challenging the charges or the facts of the case and be sentenced as a minor. So I would say without this movement, there is no way that that we'd be here at the federal level being able to challenge this in our federal system. The last thing I want to say before I turn it back over to Allison is that this is, while the charges are oftentimes serious for young people that are automatically charged as an adult, there is absolutely no research that shows that harsh punishment does anything for public safety. We know it does tremendous harm to the child. We know it does tremendous harm to communities, because we know that communities that face this overwhelmingly are communities filled with young Black men. And we know that the juvenile justice system is equipped to handle these kids. So if we should be asking ourselves ever when children need the most due process protections, the most the most access to attorneys, all of those pieces, it should be when they're facing the most serious charges. So I really want to applaud Ms. Bass for her leadership on this, and want to encourage all of you. Again, the bill number is 2908, and I want you to look at it closely, because there's also really good information in there around minimum age and some grants to states to make sure that we have other support systems and communities that can take care of our children. Back to you, Allison.
Yeah, thank you so much. So the other bill that's currently pending in Congress really focuses on extreme sentences and with a provision that protects the children against sex crimes. So we're going to turn it over to James to talk more about extreme sentences, and then we'll turn it to Yasmin.
Great. Thank you so much, Allison. And thanks to NJJN and CJJ for sponsoring this event, and for all of my fellow panelists. It's really exciting to be here with you all talking about these issues. And, you know, one of the points that I really want to drive home as we think about this last bill in the package is, you know, how we think about kids who are subject to transfer and then are sentenced as adults. I think for so long, there has been this misperception among the public, among funders, among even folks in the space, perhaps, that the population is a relatively small one that we're talking about, right? But we know that's not true, because we know that on average, right, every year, approximately 76,000 children are, at least their charges are initiated in the adult criminal legal system. And then of that population, 83% of those kids are racial minorities. Right. So then there's this big question, well, like, what has happened historically over time to all of those kids each year who get prosecuted as adults? What's going on with them? Where are they now? Who are they? And that's an important question that the field, you know, to be just quite frank, hasn't really grappled with yet. We have started to collect anecdotal data from states on what is the total population of people who are currently incarcerated in adult prisons today for crimes that they committed as children, right? And so what we're beginning to see, or at least the glimpse that we're beginning to find, is that there's a significant portion of the adult population, or it's not huge in proportion to mass incarceration, the 2.2 million people that are incarcerated in our criminal legal system now, but it is a sizable portion that generally what we're finding varies between 3 to 7% of the entire prison population are folks who were there for crimes that were committed as children. And so one of the things that says to me when we're looking at this data, when we're looking at the criminal justice reforms that have been able to take hold at the state level and that are now being mainstreamed through the federal bill package that has been introduced, is that our kids really are the kids who are prosecuted as adults. We need to really look at them as the dreamers of the criminal legal reform movement, right? I've been trying to speak to folks about the fact that, you know, unless we are all successful in changing the way that we treat children in the legal system and the adult system, we have no prayer of ending mass incarceration in America, right? And so these populations are inextricably linked. And it's something that we need the public to understand, and it's something we need foundations to understand. It's something that we need everyone to understand, because, you know, the policymakers by and large are a lot more sympathetic and are a lot more empathetic to the plight of children than they are to anybody else. And so, you know, I think that is a message that we have to continue to lift up. We have to continue to talk about our children through this more empathetic and sympathetic lens. And a powerful way to do that, I think, is through this broader human rights frame, right? And that's one of the things Michael mentioned, the report earlier that we put out last year. You know, all of these issues that we're talking about, whether it's kids transferred to the adult system, whether it's protecting kids at the point of interrogation, these are basic human rights norms that have been embraced the world over. We are a global outlier when it comes to how we treat children in the legal system. It is the largest government-sanctioned human rights abuse against children in the world today. And I think we have to start calling it for what it is, particularly when we start looking at the egregious practice of sentencing and trying and sentencing children as adults. They've been explicitly spelled out in the UN Convention on the Rights of the Child, Articles 37 and 40, as well as Articles 10 and 14 of the International Covenant on Civil and Political Rights, which the United States is a party to. And I want to back up as I sort of give my remarks, and I'm going to be cognizant of time, because sometimes I get on my soapbox and I can just run over and over, and I've got to share my time with Yasmin, who has some phenomenal data to share as well. But, you know, to understand how we got here, where we're trying so many kids in the adult legal system, where they're getting these harsh punishments, mandatory minimums, extreme punishments like life without parole and de facto life without parole. We really have to go back to the 1980s and 1990s. Everyone is familiar with this time period. Juvenile crime wave happens. A group of criminologists theorize that there's a new group of super predator children who they term, quote unquote, are godless, jobless, and fatherless monsters. And that unless lawmakers do something about this to stem the coming blood flow, these kids are going to overrun the streets, and it'll be pandemonium. And so lawmakers respond by making it easier to transfer and try children in the adult legal system, right? So this is happening at the same time that the UN Convention on the Rights of the Child is ratified in 1989. Right. And it's important to understand why this happens specifically in the United States. When we talk about human rights atrocities and human rights abuses, whether you're talking about what happened during the Holocaust, Rwanda, pick any major genocide or human rights atrocity that's happened in our history, it is always preceded by a deliberate attempt at dehumanizing the population that is the subject of the attack. So by talking about children, Black children, mostly Black and brown children, right, as super predators, as calling them godless, as calling them fatherless, as calling them monsters, it makes it easier to do unspeakable things to them because they're not our kids, right? And so that's how we got here as a nation. That is also why this issue is inextricably linked to the fight for racial justice. You cannot talk about how we treat our kids in the adult legal system without talking about the history of how we got here. And you can tie that all the way back to, all of the other struggles for racial justice in this country, whether you want to go back as far as slavery to Jim Crow and all the way through, there's a through line to our kids and our population, right? So fast forward the clock real quick, 2005, the US Supreme Court begins to weigh in on the heels of emerging juvenile brain and behavioral development science that shows that there are fundamental differences between juvenile and adult brains. This is something the court opined that every parent or grandparent knows, but thermal brain scanning imagery was able to show conclusively. And the court specifically highlighted a couple of things, right? They highlighted that, kids, they're more impetuous, less able to control the external environment in which they grow up. And as a result, that diminishes their culpability wholesale when you're talking about offenses that are committed by adults versus juvenile offenders. The other thing that the court noted was that children, because of this dynamic, have a unique capacity for growth, rehabilitation, and change over time. And the court also noted that, because many of these children grow up in these horrific crime-producing settings, right, that also means that there's this trauma component that goes along with it, right? And it's unsurprising that when we look at the adverse childhood experiences data, when we look at this population, it's through the roof. And the more serious the crime is that we're talking about, the higher the ACE score. So for example, for kids that have been sentenced to life without parole, roughly 50% of them had experienced violence in their home on a regular basis. They had seen violence in their neighborhood on a regular basis. For girls who've been subject to these sentences, and Yasmin's going to talk about this a little bit more, the numbers are even more atrocious, where 80% of them have experienced both physical and sexual violence. So there's this direct correlation between trauma and kids who end up at the deep end of our criminal legal system. 5 years later, the court outlaws life without parole for non-homicide crimes in Graham v. Florida. Again, sort of going off that same line of logic and thinking about juvenile brain development and how kids are different from adults. And then in 2012 and 2016 again, and then even more recently in 2021 in Jones v. Mississippi, the court affirmed that mandatory life without parole is unconstitutional for juvenile offenders, and that prohibition also applies retroactively. So in light of all of this, we've seen significant movement around the country today. 25 states and the District of Columbia banned the use of life without parole sentences on children. At the time that Miller was decided, there were close to 2,500 people serving life without parole sentences. That's not to say the number of people also who are serving what we term sort of de facto life without parole sentences, right? And that number is closer to 10,000 people nationally who are currently in our prisons for crimes that they committed as children serving life sentences. So a significant portion, right? But over the years, because of the Supreme Court decision and because of retroactive legislation that has given people the opportunity either to go back before a judge or before a parole board, that population has significantly diminished as a result of that. And early on, back in 2015, Senator Grassley actually was one of the first senators to ever file legislation to end juvenile life without parole, and that was in the Sentencing Reform and Corrections Act. Of course, that did not pass. It was reintroduced again in 2017, and then we fought like heck to try to get it included in the First Step Act that President Trump signed back in 2018. Unfortunately, it was left out of that. During that time, Congressman Bruce Westerman also stepped up because his home state of Arkansas was one of the first states in the Deep South to actually retroactively ban juvenile life without parole, impacting more than 100 people in his home state. And so he took this issue up back in 2017, filed legislation that mirrored what Senator Grassley had introduced over on the Senate side. And every Congress since then has continued to reintroduce that legislation. Over the years, he also updated that bill to include allowing judges to deviate from mandatory minimum sentences. And this is something where we're still trying to gain traction on nationally, as only a handful of states have actually enacted legislation that has ended the application of mandatory minimums for children. And that includes states like Washington, Virginia, and then most recently, Maryland, where judges are allowed to deviate from any mandatory minimum sentence that the child may be subject to. And then there's other states like Nevada that allow judges to deviate up to a certain percentage away from that sentence. And so that's the bill that Congressman Westerman has. That's the other provision in his bill that allows judges to deviate up to 35% away from the otherwise required mandatory minimum after the judge considers the impact of childhood trauma on the child's behavior and how they ended up in the justice system to begin with. So one easy way to think about these reforms before I turn it over to Yasmin is sort of the dual track, right? So typically what we talk about is back-end reforms, and this is the ban on juvenile life without parole, judicial sentencing review. It's for people who are currently incarcerated, who have served a minimum of 20 years in prison. They have the ability to petition a judge for sentencing review and potential modification. The judge goes through, considers a variety of factors, including everything that was going on in the child's life at the time of the offense, how much they've grown and changed over time, as well as the recommendation of the U.S. Attorney's Office and the Bureau of Prisons. And so it really is sort of the safety valve to get kids who've already served lengthy periods of incarceration out of prison now that they're, older in life. We're talking 35, 40, 45, 50 years. Tons of folks are coming home much, much later where they've served 40, 50, 60 years of incarceration. We have people in our prisons today, this is important for folks to understand, who committed their crimes as children who've been incarcerated since President Kennedy was in office. So just think about that when we're talking, to kind of put into context the population that we're talking about and how long they've been incarcerated, right? And then the front end reform, which is allowing judges to deviate from mandatory minimums on the front end and making sure that child status as well as trauma history is the two determining factors of how judges are going to craft sentences once we've tried children as adults. Obviously, our big picture goal is to eventually get all kids out of the adult system entirely. But until we're able to do that, we have to sort of work with the system as it currently exists. And that means allowing judges to deviate from mandatory minimums so we don't get kids who serve these lengthy and harsh prison sentences. And so with that, I'm going to go ahead and turn it over to Yasmin to talk about girls in the system.
Thank you so much, James. And thank you everyone for the opportunity to be here. I'm Yasmin Bafa with Rights for Girls, an organization working to defend the rights of girls and young women at the intersections of violence and incarceration. And so I'm thrilled today to be joining my colleagues to draw attention to these glaring human rights abuses of some of our nation's most vulnerable children. And I'm here today to get to highlight these injustices, particularly as they apply to girls in the system. So I think first, it's really important to recognize that all of these conversations are happening against a backdrop of a cultural recognition around the harms of systemic racism, as well as renewed commitments to ending things like mass incarceration, challenging and ending predatory policing policies. But at the same time, we've also been witnessing a national reckoning around the harms of gendered and patriarchal violence. So every day we're seeing brave survivors speaking out to demand justice and safety all across the country. But rarely has there been an appreciation about the ways in which these two movements overlap and manifest in the daily lives of children, and especially girls of color. And so I'm really grateful to have that opportunity today to talk about what's happening to so many girls across the country who suffer as a result of both over-policing and under protection at the hands of the state, and both of which land them behind bars. And so first, it's critically important to just understand how pervasive gendered violence is in our communities. We know, for example, from the CDC that 1 in 4 American girls will experience some form of sexual violence before reaching the age of 18. But those rates are even more staggering for girls and young women of color. So for example, we know that 60% of Black girls will experience sexual violence before their 18th birthday. Over 90% of Native women and girls experience rape or sexual assault in their lifetime, and oftentimes by individuals of another race. So instead of being seen or treated as victims of crime and child abuse, too often our systems blame and punish these survivors as criminals, subjecting them to what we at Rights for Girls call the abuse to prison pipeline. And so, why does this happen? Well, I think my colleagues talked a lot about this concept of adultification of young people. But there was a report that came out a couple of years ago out of the Georgetown Law Center on poverty and inequality called Girlhood Interrupted. And it specifically drills down on this concept of adultification with respect to Black girls in particular. And what they ultimately found was that adults who encounter Black girls view them as less innocent. They tend to view them as more knowledgeable about things like sex. They see them as less in need of nurturing and care. And so it's really important to realize that and how this ultimately shapes how adults as well as our systems respond. And it helps explain why we have so much victim blaming, punishment, and a fundamental lack of empathy when it comes to girls and young women of color, and particularly Black girls. So in our work, we started to collect data from across the country, really trying to see if this was, isolated jurisdictions or if this was a larger pattern. And unfortunately, we found from some of the available national data that this was a huge pattern. And so when we looked at the national data, we found that about 73% of girls behind bars reported past histories of abuse, physical and sexual abuse. Those numbers were even higher in certain jurisdictions. And we also looked at the rates of sexual and physical violence for girls sentenced to life as children and found that about 77% have suffered sexual violence and about 80% had suffered physical violence prior to committing their offense. And so when we fail to take these trauma-informed steps or address the harm that young people have experienced, it really sets them up on a path of more victimization, future incarceration, and promotes more dangerous and risky behaviors. And ultimately that can include harming others as a means of self-preservation and ultimately as a form of self-protection. And so this really brings us to the crux of the issue I wanted to talk about in the context of the bill James just mentioned, Sarah's Law and the Unfair Sentencing of Youth Act, HR 2858, sponsored by Representative Westerman. We were also able to get this legislation incorporated into this year's Trafficking Victims Protection Act reauthorization, HR 5150, sponsored by Representatives Chris Smith and Karen Bass. And so really it recognizes that we need to consider both the impact of the developmental differences between children and adults, but also account for survivors and how years of childhood sexual abuse can actually promote them acting out against those who have harmed them. So again, unfortunately, these cases are rarely regarded as self-defense when we're talking about, young people who are often children of color, especially girls of color. And instead, we are seeing that most often these girls are tried, often sentenced as adults to lengthy prison sentences, where they don't get to receive any of the treatment. And really, it just adds and exacerbates the layers of trauma and pain that they've already endured. And so I think some of the most prominent examples worth highlighting, many people became aware of the Centoya Brown case. She was a young child trafficking survivor out of Tennessee who at age 16 was incarcerated. She was convicted to life sentence, labeled a child prostitute, without regard to the fact that she was too young to consent to sex. What we often say is there's no such thing as a child prostitute. Federal and state laws recognize children in the sex trade who are under 18 as victims of human trafficking, but nonetheless, she was tried and sentenced to life for killing her adult sex buyer, right? Not seen as a victim, not seen as self-defense, not seen as a survivor of serial commercial rape in this case. And so there's many other cases like hers. I tend to say, conservatively dozens, if not hundreds of cases like Centoya's. There's several pending right now that we are working to support. Crystal Kaiser is a young African-American girl in Wisconsin who is facing charges and currently awaiting trial for the alleged killing of her child pornographer, her kidnapper, her child sex trafficker. There's Zeffie Trevino, who is tried as an adult, and she was 16 years old at the time of this offense. She didn't even pull the trigger in her case against her adult sex buyer, but nonetheless, she is facing capital murder charges in Texas. And so again, these cases really say a lot about who gets to be seen as a crime victim, who gets to be seen as a child in our society. And so one of the key tools to dismantling this pipeline is Sarah's Law, as we mentioned, HR 2858, named after Sarah Cruzan, who's another child trafficking survivor who unjustly was criminalized for acting out against her trafficker and served over 20 years before she was released. And so this bill would take a number of steps to help recognize the acute trauma experienced by child victims and respond in a more trauma-informed manner. And so James talked about how it would retroactively end life and de facto life without parole sentences by allowing individuals convicted of crimes as children the ability to petition for resentencing and review after serving 20 years, allows judges to depart from mandatory minimum when sentencing children. And critically, in this case, it would allow the protection of child sex crime victims from harsh sentencing when they act out and commit acts of violence against their harm doers. And so again, there's a number of states that are working on similar legislation. I know James has worked to promote state versions of Sarah's Law in a number of states, but we also know some states have promoted this in the context of domestic violence or family violence. So for example, New York's Domestic Violence Survivors Justice Act has helped to release a number of survivors, most recently and prominently Patrice Smith. And right now, California is grappling with their own version of this law called AB 124. I think it's being led by the National Center for Youth Law, Young Women's Freedom Center, and other allies. And I know they're eager for support to help get Governor Newsom to sign that legislation into law. And so again, I would just, in these last couple of minutes, encourage you to look to see what your state is doing. If anything, I know all of us here would be eager to help support these efforts and to make sure that any type of legislation that would allow for this trauma-informed sentencing when it comes to child sex crime victims to consider things like sexual abuse, domestic family violence, and things like sex trafficking, as that is a growing form of violence and exploitation that we're seeing young children and particularly girls of color experience. And so with that, I'll pass it back to Allison.
Yeah, thank you all so much for your brilliant insights into everything happening on the federal level. A number of questions have come in on the federal legislation, and so I just want to try to be responsive there. So, you know, October is Youth Justice Action Month, and really we do want to focus on the action portion of it. So our speakers highlighted the federal package that's being pushed through Congress, and folks are rallying support around human rights for kids, as well as NJDN and a number of other organizations, Anti-Recidivism Coalition, others on this phone, or others on this call, created a petition in support of that federal bill package. And so I just dropped it into the chat. If folks are able to sign that petition in support of the package, it includes Congressman Cardenas's interrogation bill, Karen Bass's bill on both establishing a minimum age of juvenile court jurisdiction, as well as a minimum juvenile and adult court age, as well as Westerman's bill on the sentencing reform and ending life without parole in Sarah's Law. So all of the legislation we talked about today, if you sign this one petition, it will show support for all of those, and we would greatly appreciate you taking a moment to do so. I know that there were a few other questions that came up in terms of resources, and so we put the Act for JJ federal policy recommendations in there. That's all the legislation from this week, as well as previous weeks that we've talked about federal legislation. Those information on each of those bills is included in that fact sheet. And then James Stoll, thank you, just put in the link to the federal issue brief, which is also on the federal bill package. So I know a couple other questions had come in during the conversation. I wanted to make sure we provided space for that. If you have other questions at this time, please start putting them in the chat and we can refer those. But I know Laura Furr asked a question about California's law, and it looks like, Marcy, you put that response in the chat, but I wondered if, Michael, you wanted to talk a little bit more about how attorneys are provided to kids in California.
Yeah, so we are a very big state, and we are very, very fortunate that part of the requirements that were passed in SB 203, which I'll try to share that bill and the analysis of it with you all, was that it didn't have to be just in person. An attorney could be made available in every county, which already has a system in place, sort of like a hotline, if you will, where kids can also receive this consultation by phone or by video, because we did understand that we are such a big state, and there may be times, for example, to the question non-working hours, that it would be difficult. And so we made sure that within the law that was being passed, part of the provisions would ensure that it was not just by in person, but by phone and by video to get around that.
Thank you so much. And I was trying to pull up the California legislation as well while you were talking, but I wasn't successful. So if you're able to, Michael, that'd be incredibly helpful. Somebody else asked whether this is recorded and whether we'll share out the research and congressional action links. And the answer is yes. It usually takes us a little while to finalize the recording and get it up, but we will share that with you guys, as well as the link to the petition, all of the legislation, and the state ratings report. So are there other questions? If so, I'm trying to scroll through, but please pop them in the chat, or I'm happy to call folks out. If you can unmute yourself, you're welcome to. Marcy has a question.
I don't have a question, but I have something to encourage people on the call. First of all, it's really great to see this webinar so fully packed. I want to thank everyone for taking time out of your day. We know how exhausting it is to be on webinars these days. But I want to note something that every panelist has talked about on this call, and that is that the federal government is behind. We're trailing behind at the federal level of what states are doing locally. And I say that because I think it's really important that we share our wins locally with our members of Congress. James started out, and Michael both started out talking about the one thing we've been very fortunate about in the youth justice movement on Capitol Hill is that it's been very bipartisan, sorry. And I think when you listen to what has been passed and some of the movement that has been made, you will see that it is not just in one part of the country. It's actually happening across the country. As we learn more about trauma, as we learn more about effective community-based responses, as we learn more about gender and race violence and what we can do to start to tackle these things systematically, states are way far ahead. And, you know, we are talking about a handful of bills today that go that are really important, but there's also administrative action now and to put money up to close youth prisons and to take the money that states can save by closing these ineffective big youth facilities that are frankly more than half empty in most places, and investing that money instead in communities. And so so I just urge you to call, even if your state hasn't done this yet. Let your members of Congress know that you're watching, that youth justice needs to be part of their priority agenda. I mean, we had Mr. Biden, you know, because he put out as a campaign promise some of these things, you know, he is now obligated to try to move some of those things. And so, you know, we a lot of times are asked, what is the connection between federal and local momentum? And I think this is a really good example of where this can happen. We had just this year, in terms of direct file, DC has a bill. They just had a hearing this week. We had fair and just prosecution testify, and several other former prosecutors that testify to end direct file in the district. The bill was led by our elected Attorney General. The Attorney General in Maryland has called for the end of automatic transfer there. In Pennsylvania, the task force there came up with ending direct file. So we're starting to understand that this is a practice that doesn't work, that children need to have a full hearing at a minimum until we can get to what James said of ending transfer altogether. We need to, at a minimum, be taking these protective steps for children. Things like departures from mandatory minimums, looking at trauma history, understanding where children come from, earlier interventions with crisis response for families who are exposed to violence, whether that's in the home or in the community. There's a lot we can be doing right now, and we need all of us to talk with one voice. So I just encourage you to stay active and to make those phone calls.
Thanks so much, Marcy. And I know, sorry, James, you're going to unmute yourself. I was going to see if you wanted to talk a little bit about some of the follow-up actions that are pending and ways folks can get involved.
Yeah, so a couple of really great ways for folks to get involved. Later this month, there's going to be a floor vote in the Senate on the legislation that will end juvenile life without parole. It potentially will become a vehicle for us to use to hopefully get some of these other JJ provisions eventually into the bill as well. But we really need some sort of vehicle to be able to move. As folks know, the broader movement suffered a big setback with the death of the George Floyd and Policing Act. And so, power doesn't mean anything unless you can do something with it and you can deliver for the communities that have been impacted. And so we really need this bill to go forward, and we really need for the federal government to step up and end juvenile life without parole. So as a starting point, I would highly encourage folks to be on the lookout for action alerts that are going to be coming out, I assume probably from all of our groups, NJJN, Sentencing Project, CJJ, certainly our friends at the Campaign for the Fair Sentencing of Youth and Represent Justice are going to be putting out some of that model language in the action alerts that we can use. Actually, Represent Justice, and I'll put this in the chat box, they have a great landing page that folks can go to, and it's real simple and easy to use. You just put in your address, your name, and it'll do an automatic filler. So the email will be sent. I think there's even an option to do like a tweet, and you can contact your senators and say, hey, please support ending life without parole sentences for kids at the federal level. So we're kind of getting into the end game here on that particular provision in the Senate, and that'll be coming up soon. So please stay engaged and active on that, and I'll make sure we find the link and we'll put it in. But that would be great to share with your networks and get folks activated that way. The other thing for folks that are in DC, that are local, we're going to be having a press conference next Thursday at 10 a.m. A number of folks on the call are going to be speaking. We're also going to have Congresswoman Karen Bass along with Congressman Tony Cardenas. They have confirmed that they will be speaking at this event, 10 a.m. in the House Triangle right outside of the U.S. Capitol building. We're still working on a couple of other folks. We're hoping that Congressman Bruce Westerman will be there, and Senator Durbin, and potentially Senator Grassley. We have asks out to their offices as well. So, it's really, to uplift everything that's happening with YJAM and the incredible work that CJJ and NJJN have done, and then also call attention to these broader bills that are pending that we really need that U.S. House to take up and make sure get prioritized, as we talk about criminal justice reform moving forward. So we're trying to have a big footprint out there. We'd love for tons of folks to come out. And I will also put that link in the web chat function as well, so folks can RSVP if you are in the DC region. And then lastly, just continuing to uplift all of the messaging that's coming out this week from all of the different organizations. YJAM is a great opportunity for folks to get involved, spread awareness, and really speak with one voice. And so those were the things that I would really highlight. Oh, the last thing I'll say, I'm hoping that our timeline is going to work for the next iteration, the 2021 version of the state ratings report to come out. What we're hoping to have this time around is individual state reports. So you will be able to go on our website, download your individual state report to see specifically the statutes that your state got credit for and the analysis for why you did not get credit. It's a great opportunity for you to take that report, send it to your local legislator and say, hey, we're abusing the human rights of our children. Why are we doing this, right? And I think that they use, we were able to use this to great effect in Maryland. I'm going to put in the chat box right now an op-ed that Jenny Egan, who's the chief of the public defender's office for the juveniles and I did toward the end of the last legislative session. I know Jenny was big on that. Every time she was testifying, like, we're rated last in the nation, we're rated last in the nation, you know. And so it becomes a very powerful talking point, particularly for folks that are in quote unquote like more blue or liberal leaning states, to like show like, yo, you guys are behind North Dakota and Arkansas, right? And be as progressive as Arkansas was one of the things that I said to the chair of the Maryland Judiciary Committee, right? Like, it was just like, hey, be as progressive as the most conservative states. That's all we're asking for. And I think that, you know, that kind of messaging, it kind of stings a little bit for, I think, Democrats who typically tend to think that they're better on these issues than Republicans. And the reality is that's just not the case. When you look at the states in particular that have banned juvenile life without parole, there's a lot of conservative states there: West Virginia, Utah, Arkansas, right? North Dakota, South Dakota. You know, you don't see on that list, you don't see Illinois on that list. You know, you don't see New York on that list. You know, so these sort of traditional liberal strongholds like are well behind the curve on a lot of these issues when it comes to how conservative states have outpaced them. So that report and the messaging around this broader human rights frame, I think, is very effective and can be very effective for folks. I just saw too, it was cited too in the Tennessee Outlook. Folks probably saw that horrific report that came out of Tennessee with the number of kids who were brought up on you know, charges that didn't exist. It's the very definition of government tyranny. But that's another, you know, that's another soapbox for me to get on. But like that, one of the articles cited to the report as well, talking about how bad Tennessee is when it comes to human rights violations, because they were also one of the worst human rights abusers in our report from last year. So definitely use that framing. I think it's helpful, and I think it'll help to get folks motivated in your home states of taking these issues up.
Any last questions from folks? I will say there's still a lot of folks on, and we still have 30 minutes left. So part of our original goal with this was to at least provide space for those who still want to talk with experts about how you can move this in your own jurisdiction. So I'm going to call an audible for our expert panelists here, but we're going to at least throw up the option for folks to hop into breakouts if you want. So the different breakout rooms would be girls issues, extreme sentences, interrogation, and transfer and direct file. So if you're working on a state level or state campaign to advance these issues, we just wanted to create a little bit of space for you to get ideas from the folks who've moved these issues on in so many states. So I'm going to open the breakout rooms for anyone who wants to hop in. I'll monitor those, and folks can ask any relevant questions there. But we want to thank you for your time for those hopping off, and also just remind folks to please take action by signing the petition. So thank you guys.